Welcome to Tomkins Talks. So, you hopefully know the drill by now. I give you a summary of a recent case in a short, snappy way that's easy to digest whether you're at home, in the office, or on the move. However, this is a Tomkins Talks with a difference. It's the first one whilst we've been on lockdown, so I'm doing it from home in slightly more relaxed attire and without the help and support of Eleanor Watson and Cam Jones from our fantastic business development team. So it won't be as wizzy as usual, but I hope you'll still enjoy it. One of the difference is that rather than looking at a case, I'm going to talk about a piece of legislation that was passed last week, the Coronavirus Act. Now, whilst most of the Act deals with issues concerning the virus, including the health service and the supply of food, there's one section that's relevant to commercial leases. This is Section 82. The key part of this section imposes a moratorium on forfeiture of commercial leases before the 30th of June 2020, where tenants fail to pay sums due under their lease. Now, as you can probably imagine, I've had lots of questions from landlords and tenants on this legislation over the past week, so I thought I would address some of them on here. Question 1. What is a landlord prevented from doing under the Act? Well, there are three key things. Number 1, landlords may not forfeit commercial leases as a result of a tenant failing to pay the rent or any sum due under the lease on or before the 30th of June 2020. Number 2, courts should not grant orders terminating commercial leases on the basis of forfeiture that result in a tenant having to give up possession before the 30th of June 2020. And number 3, if landlords are opposing the grant of new business tenancy under the Landlord and Tenant Act 1954 on the basis the tenant persistently delays in paying the rent, they cannot rely on a tenant's failure to pay the rent from the March quarter day until the 30th of June 2020. Okay, question 2. Do the restrictions apply to all commercial tenancies? Well, the answer is pretty much. Any premises occupied by a tenant for the purposes of their business will be caught, save for some limited exceptions, such as fixed-term tenancies for 6 months or less, agricultural tenancies, and tenancies at will. Question 3. Does the Act mean that tenants don't have to pay their rent? Well, in a word, no. The rent is still due and payable. The Act simply removes one remedy available to a landlord where it's not paid. Question 4. What options are available to a landlord if a tenant doesn't pay the rent? Well, the other usual remedies are available, such as court proceedings, commercial rent arrears recovery, although I must say I'm unsure how practical this will be, given bailiffs may not be able to attend premises, insolvency processes, such as the service of a statutory demand or the presentation of a winding up petition, but do note there are rumblings the government may also prevent winding up petitions being presented for a time. Landlords can also claim interest, pursue guarantors, and take sums from rent deposits. Question 5. Does this have an impact on a condition of a break clause to pay the rent? Well, I don't think so. The rent is still due and owing, so if a break is conditional on a tenant paying the rent that's fallen due, the March quarter rent will need to be paid in full. And question 6. What happens once the Act ceases to apply? Well, normal service will be resumed. Landlords will be able to take steps to forfeit leases in respect to the failure to pay the rent during the March quarter, unless they've expressly waived the right to do so. Now, I'm sure there will be other questions that you may have, so please do feel free to get in touch if you have them. If you found this useful, please do comment, like or share this video. I'll see you soon for another Tomkins Talks, and I hope that you and yours stay safe and well.